treaties of the EU, and EU law is based on the treaties, enshrine the principle that in the domains of EU competence, European law takes precedence over national law. And in cases of dispute and the interpretation of that law, the European Court of Justice has the final authority. Maybe this made sense in the first decades of its existence, when what has now become the European Union only dealt with technical and economic matters and left sensitive social and moral issues entirely in the national sphere. In fact, because of the early adoption of a common agricultural policy, animal welfare conditions in relation to intensive farming methods and the transport of animals over long distances were the first issues with an ethical dimension to be a matter of concern to European decision makers. It was not until the adoption of the Maastricht Treaty in 1992 that the EU was given any competence to deal with non-economic matters. In agriculture, as in other developing industrial policy areas, the EU's primary focus has always been on trying to achieve a single policy approach which is common across the member states, who are all thereby committed to adopting a uniform set of standards. Special treatment, whether for different national standards for the content of beers on the one hand, or safety requirements for the manufacture of motor cars on the other, were to be discouraged. However, significant national differences in approach taken to key controversial ethical and moral issues still remain. And this causes problems for Christians. And it's been a key concern of the NGOs that I represent to monitor whether and to what extent these differences which are there in national cultures and national laws are being adequately taken into account in the development of new laws and policies by the EU institutions. And I'm just going to run through a few examples of how in the past decade these issues have come up. Contemporary threats to Christian values. Family law. Just a bit more background. The EU institutions are increasingly seeking to influence national practice in the area of social issues previously felt to be a matter of subsidiarity. Seeming safeguards in the treaties appear to have been all too easily got around by reclassifying the issue to appear under a different heading or a different article of the treaties where action is not restricted, or just by putting a new and unexpected interpretation on the treaty wording. Take the area of family law, for instance. Is not supposed to be a European competence, but under immigration law, freedom of movement of workers means you must let in non-European nationals who are the EU citizen workers' family members. But under whose definition of what a family is? Also under the guise of employment law, the European Court of Justice has now effectively imposed a particular interpretation of family law on member states by ruling inter alia that private occupational pension schemes must make the same provision for gay partners as for a married spouse, where any sort of civil registration process for same-sex partnerships has been established. A landmark example of this was the Maruco ruling under the 2000 Equal Treatment in Employment Directive. Despite the fact that recital 22 of the directive states this directive is without prejudice to national laws on marital status and the benefits dependent thereon, the judges ruled that a surviving gay partner must receive the same benefit as a married widow would have done, and the relevant German law which prevented that must be struck down. Their comments included the statement that civil status and the benefits flowing therefrom are matters which fall within the competence of member states. However, it must be recalled that in the exercise of that competence, the member states must comply with European Community law, and in particular with the provisions relating to the principle of non-discrimination. Research funding. The European Commission proposal for the 7th Framework Research Funding Programme in 2005 included using material abstracted from the earliest human life form, the pre-implantation embryo, although with the proviso that these had to be extracted from supernumerary IVF embryos and not embryos deliberately created for research purposes. However, it could be argued that it would be inappropriate for money from the common European purse, to which all states had contributed, to be used to fund such research, which would have constituted an illegal act had the money been dispersed in, at that time, a substantial minority of member states, 8 of them at the time. Not only was there an offence against national ethical conscience here, but also an issue of equity, as the funding of such research would mean that there were parts of the funding programme which would not be open to bidding by applicants from all member states. The European Commission line was challenged by a number of amendments during its passage through the European Parliament, and the Legal Affairs Committee ruled against them, but then other committees ruled in a different direction. But they were all defeated, although the last amendment was by a margin of only 19 votes when it came to the plenary session. In 2013, we went through the legislative process on the Horizon 2020, which is the latest research funding programme. But unfortunately, in this case, they choose to use a thing called the first reading agreement procedure, which I haven't got time to go into now, which meant that everything was stitched up in closed doors, and the final vote in plenary was just an up and down vote with no chance for amendment. So the position on embryonic stem cell research was not changed, even though, again, this time the Legal Affairs Committee very clearly ruled that it would be unethical to continue it. Authorization of novel therapies, which is not merely drug or surgical procedure based, things like somatic cell therapy, gene therapy, tissue engineering. There was a new regulation for this proposed in 2005. At the time of the advance was being drafted by the European Commission, I argued that it should be considered under Treaty Article 152 for health matters, as this makes clear provision for national subsidiarity, because it requires all measures enacted under it to fully respect the responsibilities of the member states for the organisation and delivery of health services and medical care. But the Commission was adamant that single market legislation under what was then Article 95 would be more appropriate, even though that always presumes complete harmonisation, and national exceptions are always very restricted and subject to challenge at the European Court of Justice. Wording was proposed by the European Parliament's Legal Affairs Committee to exclude embryonic and fetal cells to prevent this, but their recommendations were strongly opposed by the European Commission, and it was eventually overturned at a plenary vote in the final text of the regulation adopted in 2007. Requiring embryonic cells, sorry, I'm not keeping up with this, am I? To be used for product testing. The issue of the protection of early human life also came up in the debate over revision of the Animal Testing Directive, which started in 2008. This provides that the use of animals in the safety testing of new products for human use should be minimised, inter alia by the compulsory use of any authorised alternative testing methods not involving the use of animals. At the same time, under that 7th Framework Research Programme, the European Commission was funding research to develop the use of human embryonic stem cells as an alternative to testing new substances on animals. In fact, it's one of the largest grants under the 7th Framework Programme, whereas the ethical justification for the 7th Framework Programme position from the European Group on Ethics was that we had to make an exception because of the needs of human health. And here's nothing to do with human health, it's to do with protecting animals. Sorry, that was a diversion. In the amendments were adopted exempting states with specific legislation protecting the early embryo from these provisions. But the question of what might happen in states where use of embryonic and or fetal cells is more or less strictly restricted but not actually prohibited in statute is still uncertain. Access to controversial treatments. In their 2007 consultation document on the development of what later became known as the Cross-Border Healthcare Directive, the European Commission proposed that a European harmonisation of access rules for controversial treatments such as assisted reproduction technologies should be introduced. It referred to ethical inconsistencies between member states and raised the question of whether such common standards of provision for, e.g., access to fertility treatment should not be considered. It also again proposed making legislation under the Single Market Article. It was encouraged in this by a 2006 judgment of the European Court of Justice, which was actually in relation to a complaint by the United Kingdom about the application of the Cross-Border Healthcare Directive, which they felt violated principles of the Organisation of the National Health Service in the UK, that they were overruled. And the judges accepted the provision of Article 152 prevented binding obligations under community law regarding health systems, but this does not, however, exclude the possibility that the member state, compliance of the member state may be required under other treaty provisions. But on this occasion, coming back to where we were before, the idea of harmonising access to treatments, that proposal was dropped due to negative responses to the consultation, fortunately, but I'm sure it will come back. And in fact, our dear friend Edith Estrella at the European Parliament, who has done so much to promote our cause, introduced a report back in 2011 on inequalities in healthcare and advocating, again, harmonisation of access conditions. And this was supported by MEPs at the time by 379 votes to 228. And it called on member states in relation to access to assisted reproductive technologies to eliminate discrimination against women on the grounds of marital status, sexual orientation, or ethnic or cultural origins. Why it's only women and not men, I'm not sure, but that's what they voted. But fortunately, it was only Parliament giving its opinion. It's not yet legislation. But it shows you the way the thinking is going. I've just got one more item and then I'll get to my conclusion. The issue of abortion is, of course, of great concern to religious voters. Here there's no EU legislation which specifically refers to abortion. However, many reports and resolutions have been adopted, and at least one piece of legislation which includes the ambiguous expression sexual and reproductive health and rights. Although all official answers from both the European Commission and the Council of the EU, most recently this January after the defeat of the Estrella report, this year's Estrella report, consistently deny any European competence to act in the matter of abortion. Most international organisations which use this expression, certainly including UN agencies and the World Health Organization, interpret it as including access to abortion, usually under the title Preventing Unsafe Abortions. It's also frequently quoted in court cases across the world where family planning NGOs seek to pressurise Southern Hemisphere countries to allow unrestricted access to abortion. I think I'll stop there. I also had examples from anti-discrimination, but we've covered that earlier today. Let me just go to... I seem to have a missing page. We'll try and, I think it's on my PowerPoint anyway. Let's just go to it. I was asked for ideas about strategy, and there's three things I think we should be looking at in the next Parliament, but maybe some other ideas will come up. Firstly, and Roger mentioned it in his talk earlier today, is more insistence on this principle of legal certainty. We're forever battling with wording which is unclear, ambiguous, open to different interpretations. And you can be sure if that is the case, people will take different interpretations. And this ECHR principle which he quoted, I think, is very important, that people need to know when a law is passed, how it affects them, and what they can and cannot do, without having to fight expensive court cases to establish what the situation is. What happens, though, in the European Parliament is that very often, in order to get cross-party support for a final wording, texts from both sides will be incorporated. So it sort of goes in one direction, it goes in another direction at the same time. And then somehow the lawyers have to sort that out later. But I think we should try and insist on much clearer wording. And more opposition to the existence of EU-funded lobbyists. I was interested in the early discussion when it was referred to the strong power and influence of the so-called gay lobby, even though only a minority of a minority actually supported them. And the reason they're able to have such wide influence is because they don't need to have support from individuals in the general public, because they are very handsomely funded, either by US millionaires, or in the case of what goes on in Europe, by the European Commission itself, which funds these lobbies to then come back and lobby it to produce laws that these lobbies want. And that applies to the ILGA Europe, to the European Women's Lobby, and to IPPF, Mary Stopes, all these international family planning and abortion organisations. And I think with the way the elections have gone, there will be no shortage of MEPs who are willing to ask awkward questions and call into question this procedure. And more contact with and presence in the EU institutions. Our enemies in the gay lobby, the reproductive rights lobby, the atheist lobby, whatever you like to say, have very assiduously got their people into the right positions in public institutions, in government, in the EU, in the media over the past decades. We have to start working on getting our people in there as well as making obviously formal contacts as lobbyists, as NGOs and lawyers from the outside, where we can go and officially talk to people, because it is an open and transparent administration. But I've taken my time, I will stop there.